Hello, everyone. Thank you once again for joining us in this webinar today. My name is Vishal Sharma. I'm the moderator for today's session. Unfortunately, I am down with a bit of cold, so I won't have my video turned on. So yeah, we'll get started. Well, first and foremost, thank you so very much, Prashanthi, for joining us in this session today. A bit about Prashanthi. Prashanthi has had a long and illustrious career as an immigration attorney. She is an alumni with the University of Pennsylvania Law School. She has been in the immigration field since 1997. She has been admitted to the bar in New York. She's also a member of the American Immigration Lawyers Association and the New York Bar Association. She holds multiple other positions as well, including immigration chair for the National South Asian Bar Association and immigration co-chair for the Federation of Indian Associations. She is actively involved in pro bono legal work as well, and she has been awarded multiple awards for her role as an immigration lawyer. So on that note, Prashanthi, I welcome you to take over from here.
Sure. So thank you, Vishal, and thank you all for joining. I think we still have some people joining. So today, the idea was to give you some perspective on how to file H1-B CAP petitions. It's important to know how to file a petition, at least some points. I thought I'll share with you the top 10 points. And why it's important to know is so that even if you are doing it through an attorney, or you're the employee and your employer is doing it for you, or you're a company and maybe you have the HR doing these cases, but as an owner or HR or whoever it is your responsibility to check the forms when they're being done even by someone else. So no matter who you are in this game, these top 10 points will help you to check the form and ensure that the petition goes out without any issues. Also, I wanted to share some immigration updates. So we will start with immigration updates, and then we will go through the top 10 filing tips. And I promise you, if you follow these top 10 filing tips and you make sure that your form is compliant with them, your H1B will go through and it will not be returned. So that's the idea. So starting with the some immigration updates. The first update is USCIS has increased its fee. This is a proposal, sorry, to increase the fee. So there is a $600 fee increase on all I-129 and I-140 petitions. There's a proposal to cover the costs of the asylum program. This would be in addition to the regular, I-129 fee and I-140 fee that is present. So it's a fee superimposed on top of that basic fee. In addition to that, the H1B fee, which is the basic fee, is $460, and there are several other fees as well. But that basic fee of $460 is also increasing to $780. So if this proposal comes through, then the basic fee for USCIS for a H1 would be about $1,000, $1,500 or so. Also, the EB-5 investor program, the proposal is to increase it 3 times from $3,675 to $11,160. The family-based immigration applications also were not spared. We have an increase of fee, proposal to increase fee for family-based cases also. This is when you're filing for a green card, say for your spouse, for your parents, children, etc. And that is increasing from $535, which is presently the fee, the I-130 fee, to $820. So that's the I-130 application fee. In addition to that, there is also a proposal to increase the H1-B registration fee. We know it's presently $10, and the proposal is to increase it to $215. So all this is the fee has been recorded, and we're waiting for comments. Actually, the comment period also is over. So the rule is, like, the regulation has to be published. Once the regulation is published, then they wait for a comment period. And once the comment period is done, then USCIS looks into, the regulative body of USCIS looks into all the comments, and then they decide what the final law should be. So as of now, this is only a proposal. I know they have received a lot of comments, and a lot of comments have been have said that this fee increase is not a good thing. So let's see. They have been critical of this fee increase. So let's see what actually happens with reference to the fee increase. Next slide, please. Another important update, this is more a practical update, is USCIS it has specifically now said that they want separate checks for each fee. So we know with reference to H1B that there are several different kind of fees imposed on the H1B program. There's the basic fee, which is the $460, where there's the fraud fee, which is $500. And there is the ACWIA fee, which is $750 or $1,500, depending on the size of the employer. So all these three fees, they used to be combined into one fee, and a lot of people used to just send out one check. So now USCIS is saying that they want these checks to be written separately. And of course, if you're filing a H4 or you're doing premium processing, we always submit separate checks. You have to submit separate checks. But even for these different fees within the I-129 application, they want separate checks. This is, they're saying, because they're transitioning to an online system, and this electronic processing is not possible if there is one combined check there for multiple checks. It also makes sense because that way, if, for example, your premium processing check is incorrect, only the premium processing part of the fee will come back, and the entire application will not come back. And sometimes when you put one check, you might make a mistake adding up all the numbers and putting a final number. So I think it makes sense to, in any case, send out separate checks because there's less room for error. Of course, on every check, you have to make sure that the information is correct. That goes without saying. Next slide.
Sure. Before I move on to the next slide, a quick reminder for everybody who has joined us today. We will be having a Q&A session by the end of the presentation. So please have your questions ready. You can put your questions in the chat column anytime during the presentation. We will be picking it up by the end of the presentation. Thank you.
The next update is with reference to, just an update with reference to the visa approvals, what they're doing at the consulate. We know that last year, the rate of approvals or even interviews were very slow. It was difficult to get an interview appointment. Even now it is, but not as bad as it was. So the non-immigrant visa approvals, that means the number of cases that they're processing has gone up from 2.7 million in 2021 to 6.8 million in 2022. You see the difference. So we are recovering from COVID, or rather the Department of State is recovering from COVID. Slowly, not as fast as we would hope. So we see the big difference in 2021 and 2022. We don't have the numbers for 2023 as yet. Even the immigrant visa approvals, that is the green card visa approvals, they have increased the pace of processing. 2021 was 285,000, and 2022 has more than doubled. So has doubled or slightly less, 493,000. So as you can see, the overall visa numbers are starting to look more like the pre-pandemic times. So that's good news, definitely. And 2023 has improved further. We know that for a fact. Next slide. This is another update that I wanted to give you about extension for RFE response times during the pandemic. We had an automatic extension of 60 days on the RFE response times. That is 60 days grace to respond to the RFE from the last date. You can add 60 days. This is for RFEs, NOIRs, that is notice of intent to revoke, notice of intent to deny, also appeals. So there was an extension of 60 days on all these cases. Now USCIS has announced that that extension period is over. So only for RFEs received as of March 23rd, 2023, the 60 days grace period will apply. Any RFEs received after March 23rd, please make note that you will have no 60 days grace. You have to respond within the time given in the RFE. Another important and very recent announcement, in fact, as of April 21st, Labor Department has said with reference to the PERM cases that they're going to be using a new system, which is the flag system. So we have to now go and register on the flag system. And also the ETA 9089, which is the PERM form that we've been using, that has been changed as well. So there are two important changes. The flag system has already started as of April 24th. So you can go and register and stage your applications, meaning you can start filling out the application, but the system will start functioning as of May 16th. So after May 15th, you cannot use the old system anymore, nor can you use the old form. So please make note of that. If you're planning to file a green card, employment-based green card, make sure you register on this new flag system. Next. This is extremely important for those people who have filed green cards and whose children are turning 21 very soon or have already turned 21. So as of February of this year, USCIS has revised the guidance with reference to CSPA. This is Child Status Protection Act. Part of the Child Status Protection Act is that once a 485 is filed, the child's age automatically freezes. But unfortunately, the law, the way it existed earlier, was that if you have the 485 is being filed based on the dates for filing table and not based on the final action date table, then the child's age does not freeze. So you file a 485, say the child based on dates for filing. Dates for filing is basically the visa number is not actually available, but they're allowing you to file in advance because they hope that by the time they process the 485, the visa number will become available. But often dates for filing, when we file based on dates for filing, like we did thousands of cases based on that dates for filing table in 2022, in 2020 October, when a lot of numbers became available, green card numbers. A lot of 485s are still pending because the dates retrogressed, and the final action date, the 485 didn't move to the final action date, and so they were not able to actually get the green card. So those children aged out, even though they filed the 485 before they turned 21, while the 485 was pending, because the dates didn't move and they couldn't get the final approval, they aged out. So those cases where those 485s were denied. Now USCIS is saying that all those children who aged out, they can actually file a motion to reopen, which is great news. I would urge everyone to take care of take advantage of this. And also for future cases, if your child is filing with you, even if you're filing based on the dates for filing chart, your child's age will be frozen automatically. So that's a very important update to CSPA relief. Next slide. Okay, now we are going to start with the H1B CAP 10 top filing tips. Let's start with number 1, registration notice. Now, when you file for your H1B registration, if you get picked, they will send a registration notice, or they'll upload it into the portal. Please make sure when you're filing your H1 CAP petition that you include your registration notice in the H1B along with your H1B petition, otherwise it will be returned. And the problem with the case being returned is that if you're filing it later in the day, so if you're filing it in June and it gets returned in July, because they don't return it immediately, then you will not have the opportunity to file your H1B CAP petition this year and your registration will be wasted. So make sure you don't make any mistakes. You follow these top 10 filing tips so that your H1B petition is not returned. So the first tip is make sure you submit your registration notice along with the H1B petition. The H classification supplement, the H1B supplement form, I-129H, has question 5 where you have to actually write the confirmation number, the beneficiary confirmation number from the registration notice. Please make sure you don't leave that blank because then the case will be returned. Also, if something has changed from your registration notice to the I-129 application, for example, if the employer's address has changed, make sure you give an explanation, put a green sheet or an orange sheet, some kind of a colored sheet, and give an explanation as to why the address on the registration notice is different and the address on your I-129 petition is different. It could be also the case where a passport number is different because, you know, at the time of registering, you used a different passport for your employee. Now the person has an updated passport. So there could be that difference, and you have to explain that as well by submitting the old passport as well as the new passport and convincing USCIS that it's the same person that you're filing for. You're not filing for a different person. So that's important with reference to tip number 1. Let's go to tip number 2. Tip number 2, make sure you're using the right version of the forms, especially if you don't have a form software and you're pulling the form out from the, from a PDF from Google. Make sure that you're using the right version of it. The version that you have to use is November 2nd, 2022 version. That's the latest version. So all the I-129 heads, the supplement, the data, the DC form, there are 3 forms altogether. Make sure you have the current version of the form. If you do not, again, the case will come back. Tip number 3, filing fees. The filing fees have to be correct. The checks have to be dated and signed, and the correct amount has to be written on the check. I've already said that separate checks have to be provided for each type of fee. A lot of errors are due to simply because there are inaccuracies in the check. Make sure that your check is not dated more than 6 months, beyond the application date. So your check should not be more than 6 months old. If they are, again, the USCIS will not accept those checks. Even if the bank accepts them, they'll automatically reject the application and send it back. They will not send you a receipt. Sometimes the check will say not valid for more than 3 months. In that case, then you cannot send a check which is more than 3 months old. So please make sure the date of the check is always correct. The tip number 4, make sure you confirm the correct filing location. So usually when we send out a H1B, we go to the H1B, the USCIS website, and we check based on the work location where to send, which service center to send the H1B out to. But in the H1B CAP cases, it's something different. We have to send it to the address that's on the registration selection notice. So it has nothing to do with the work location or the geographic area of the service center, but it's just arbitrary. The registration notice will tell you where to send the I-129. The reason they do this is they're trying to distribute the H1-B petitions among the 4 service centers so that 4 of them have equal work and they can process cases at an equal rate, so that no one service center has an advantage and processes cases faster than some other service center, which might have a backlog if they have more cases. So make sure you send it to the address on the registration notice. Let's go to tip number 5. Make sure you sign all your forms. There is 1 signature on the I-129, 2 signatures on the H supplement, so altogether 3 signatures. If you're using an attorney, then there'll be a signature on the G28 as well. So that makes it 4 signatures. Make sure you sign in all 4 places. I can't stress this more, but oftentimes, even after we give instructions, our clients will forget to sign twice on the H1-B supplement. They'll only sign once. So there are 2 signatures, one below the other. Also, make sure you sign in the correct locations. Now, an update on the signatures. You're allowed to use photocopies of wet signatures, but you cannot use electronic signatures. So USCIS, due to the pandemic, started allowing photocopy of signatures on the I-129. On the LCA, photocopy of signature was always allowed. On the I-129, we had to actually send out original signatures, but now photocopies are allowed, but electronic signatures are not allowed. So if you sign electronically through DocuSign or some such software, then you are out of luck. Your entire petition will come back. So please make sure that your wet signature also doesn't look like an electronic signature. So that's something to keep in mind. Tip number 6. This is extremely important for all CAT cases, and I always run through this with all my office staff as well. The start date on the H1-B petition, unlike amendments and extensions where you put an immediate start date, for H1-B CAP petitions, it has to be October 1st, 2023. Remember, we're filing petitions in advance. The fiscal year starts only in October, so your H1-B start date cannot have a date before October. So it has to be either October 1 or later than that. Remember also, another deciding factor is that whenever you're filing the petition, you cannot file more than 6 months in advance. So it has to be either October 1st, or you can also, if you're filing, say you're filing April 26th. So 6 months is October 26th. So you can put a start date of October 26th. But my suggestion is put October 1 for all this batch of cases that you're filing until June. And then for if there is another registration, another selection or another lottery based on the existing registration, we will know that in July. So all those cases you will have until November to apply, because again, it's 90 days. You have to file each petition within 90 days from the date of the selection. So in those cases, you can put a date after October. But for all this first batch of cases, I suggest you put October 1st as the start date, just to avoid confusion. You also have to keep in mind that the end date is also important. The end date can't be arbitrary 3 years. You can't put a 3 years end date. The end date has to match with the LCA end date. So please make sure it matches because the validity of the LCA has to be the same as the validity of the H1-B petition. Okay. Now let's go, Vishal, to number 7. This is pretty, it's a no-brainer. You have to make sure that all the boxes are checked and completed. If you do not mark, for example, on the second page of the H1-B petition, you have type of petition. Is it an extension? Is it an amendment? Counselor processing? If you leave that blank, the entire petition will come back. So there's some tick marks that are extremely important. Now, for the ones that are not applicable, please don't leave those blank either. Just say NA. For example, they might ask for an A number, if applicable. So if you don't have an A number because you have not filed a green card or you've never filed an EAD, then you just put NA instead of leaving that box blank, right? So these are all the tips that you can ensure that you can look through even if you're not actually filing the petition yourself. Someone else filed it, sent it to you, asked you to look through it. This is a good 10 filing tips so that you can look through your form to see if it's accurate or not. Check the LCA job details. Now, this is extremely important. Your LCA has to be approved, of course, before the filing of the H1-B petition. So if there are mistakes or if the LCA information does not correspond with the H1-B information and you file your petition, the case may not come back, but you'll get an RFE. And you cannot cure that RFE. You cannot submit a new LCA because LCA has to be submitted before filing of the petition. So you cannot cure that mistake and your H1 will get denied. For example, the job title on the LCA has to match with the job title on your H1B petition, on your I-129 petition, your petitioner letter, your purchase order from your client. So all that has to be the same. Also, the work location has to match with all the documents that you have. So make sure that happens. The wage rate has to match. The LCA wage rate has to match with your I-129 wage rate, which then has to match with your employment agreement. So all that again, all the documents that you're submitting, there shouldn't be any discrepancy. Everything has to match with the LCA information. Now, if you make a mistake on the I-129, you might be able to correct it because it's possible if you get an RFE, you can correct the I-129. But if you make a mistake on the LCA, then you won't be able to correct it because, as I said, LCA has to be approved before the filing of the H1B petition. Next slide.
Sure. Before I go to the next slide, a quick reminder to everyone. If you have any questions, you can drop in your question in the chat box and we will pick it up by the end of the presentation. Thank you.
So this is a big issue with reference to filing H1Bs and has often been discussed. Point number 9, submit proof of work. There has been controversy on this because some people seem to think that because of the IT Services Cessna lawsuit that IT Serv won, you don't have to submit any proof of work because they said you don't have to submit itineraries. And that happened in 2020. But soon after that, USCIS actually issued a memo, June 12th, 2020. There's a USCIS memo. And I've actually quoted the memo word to word. Part C of the memo talks about how you have to have non-speculative specialty occupation work, how you have to show that in order to get your I-129 approved. So while they say that, they say, should an officer require evidence of day-to-day assignments to establish availability of specialty occupation work, USCIS says that you do not have to submit day-to-day assignments, and that's what we won from the IT Serv decision. You don't have to submit a detailed itinerary of your everyday work. You don't have to show that you have work for the entire duration of the H1 period that you're asking for. But you have to show that you have availability of some work. So you don't have to show day-to-day work. But USCIS says if you want to submit that, they will look at it. Next slide. But the next point number 2, the question is, may an officer deny a H1B petition on the basis that the petitioner has not described day-to-day work and has not described the nature of the specialty occupation? So there are 2 different questions here. With reference to day-to-day assignments, the USCIS says that you don't have to submit a day-to-day chart of what you're going to be doing. But the USCIS officer also says an officer The USCIS also says that an officer should deny a petition when the petitioner has not established that the beneficiary will work in a specialty occupation, which means that you have to show that you have specialty occupation work. So, which means that you cannot submit skeleton petitions without showing what work your employee will actually do. Especially if you are a consulting company, you have to submit a PO or a vendor letter or MSA, something to show where your employer will be working and for what project they'll be working. If you say that they're working on an in-house project, that you have several projects, then you'll have to submit proof of that, of the different projects that you have, and proof that they're actually existing projects and not dummy projects. So they ask a lot of questions when you say that you have an in-house project and your employee will be working for the in-house project. Now, this, of course, depends on the nature of your business. If you're not a consulting company, say you're a law firm, then really there's not much burden of proof to show that you have work, except maybe you can submit a tax return, you can submit a list of clients. Maybe you don't want to do that because it's confidential in a law firm situation. Or if you're an accounting firm, you can show the volume of your business. You can show that your business exists. You can show your website, but you don't have to show specific need, because this is not, the person is not going to be working as a consultant for other companies. So it really depends on the nature of the business with reference to what document you have to submit to show availability of specialty occupation work. Next one. This is the last one, number 10 in our H1-B cap filing tips. It's important that you submit the H4 applications, the I-539 or dependent applications along with your H1. For example, if you're on an F1 and you're filing a change of status from an F1 to H1, and if you have dependents, and if you do not submit the H4 dependent applications along with your application, your dependents will fall out of status, because you will no longer be on an F1, you will change status to a H1, and your dependents will not be able to remain on an F2, so they'll have to leave the country. Very important to submit both applications at the same time. Also very important that the validity dates on the I-129 should match with the H4 validity dates. So if you're asking for 3 years on the H1, you cannot ask for 4 years on the H4. You have to ask for the end date has to match. So on the I-539 application, so make sure the validity dates match. Also, remember that if you have children, then you don't have to, if you're submitting for spouse and children, you don't have to submit a separate I-539 form for each dependent. You have to just submit I-539A form for each additional dependent. Also, you don't have to submit a fee, an additional fee for each dependent, just one fee for all the applicants, because you're submitting only one application and you're submitting an A form which does not have any fee. So just one fee. So I-539 and I-539A forms. Also, the big advantage of submitting all these applications together is that USCIS has agreed to process all the applications together. This is a recent change with reference to USCIS. Before the pandemic, they would process all the applications together and they would approve the H1 and H4 together. But during the Trump administration, the I-539s required a biometrics. They started a new thing where all I-539 cases had to go for biometrics, meaning had to go for fingerprints and photographs. So, and then they would do a security check. So they were not able to process both the applications together because that biometrics process was taking a long time. Then they stopped requiring biometrics for, they at least suspended the requirement of biometrics for H4s, and that continues to be suspended until September of this year. They have said that they will suspend it. They will actually remove that requirement completely, but they haven't done that as yet. So as of now, it's suspended until September. So as of now, they are bundling it together, which means that if you do a H1 premium processing, then your H4 will be approved at the same time, and your H4 EAD will also be approved at the same time. We all know that if you file separately, H4s and H4 EADs, especially EADs, were taking a long time. They were taking up to 10 months to process just the EAD applications, and a lot of spouses were we're losing their jobs because nobody will wait for 10 months for an employee, right? So I think with that, Vishal, we've concluded our top 10 filing tips and our immigration updates as well.
Yes, thank you so very much, Prashanthi. So we will take up all your questions in the Q&A session shortly. I just wanted to quickly roll up how we can help you. We offer a number of services, so we can certainly book you for a consultation, and then we can take it from there. You can also check us in terms of the awards and recognitions that we've got. That just speaks the volume about the quality of services that we offer. We have raving client testimonials, and Prashanthi has won multiple immigration attorney awards, and we have excellent satisfaction rate with a big, vast clientele that we've helped them serve for the past many years now. So on that note, we will start the Q&A session. I'll quickly jump to, so now is the time for you. If you have questions, please ask. We will start taking your questions now. So we'll start with the first one, Prashanthi. How much money are we supposed to invest for applying EB-5 visa? What is the attorney fee? In how many years will the applicant get back his money from the government? After paying for EB-5, does the applicant get the EAD instantly or in few months? How long does it take to get the GC and citizen?
So he's asked a lot of questions. We can take an hour in responding to this. We have to have a separate EB-5 session, but I will try to respond very briefly. And if Gautam, if you need more information, you can always email me and we can set up a consultation. But the EB-5 investment, it is 1 million and 500,000 if you are in a place which is having a high unemployment rate. So it depends on where your workplace is or where your business is established. There is, of course, a proposal to increase this, and it has been going back and forth. They increased it, and then there was objection to it. So, there is some flux in that with reference to when that will happen. The attorney fee we should discuss privately because we don't want to be giving attorney fees out in a public forum. How many years will it take? That's a great question. My EB-5s are now taking 3+ years just for the first step to be completed. There are 2 steps to the EB-5 process. The first step is when you fill out the application and you show that you qualify and you get a temporary green card. Then within 2 years, you have to file for a removing of conditions and you file a permanent green card. And that's a separate form, and you have to show that all those conditions continue to exist, which means that the investment amount, you have used it, and you have hired 10 employees in your business, 10 full-time employees. So you have to show that that continues to exist. So that could take another few years, right? So altogether, it's not a quick process. It's 5 to 7 years to get a permanent green card simply because the processing time has become so long for EB-5s. And also it depends on whether visa numbers are available. That again depends on which country you are from. For China and some other countries, EB-5 is immigrant visa numbers are backlogged, so that counts to the time that it will take to get a green card. So there are many factors with reference to how long it takes to get the actual green card. And citizenship, once you get the green card, then you can file your citizenship 5 years after that. So you see that it takes quite a few years for the entire process to unfold.
Great. Thank you, Prashanthi. And again, just as Prashanthi mentioned, this is a classic example where if you have such detailed question, we highly recommend you book a consultation with us. Next question is, a person got through lottery visa through employer X and his spouse also got through the lottery visa through employer Y. Both their respective future employers will be applying H1 for them separately. They have a child. Is it possible for them both through their respective employers to sponsor their minor child, or just one parent can do so?
So it's not necessary for you to file two H4s, Ruchi. So you can just file one H4 and you can decide which one of you is filing the H4 for your child. So it doesn't have to be, you can save the money. You don't have to file two H4s. One is sufficient to give your child status.
There you go. That's your answer. Next question is, if you're filing COS for B1, B2 to H1B, do we need to file through consulate?
So if you're filing change of status from a B1, B2 to a H1, that is not consulate, that is change of status. But you have to keep in mind that there are difficulties in asking for a change of status from a B1, B2 to a H1. And the difficulty is the start date. As I was saying, the start date has to be October 1st. You have to file by June. So as of the date of filing, the person has to be in valid status as of the date of filing and until October 1st. So the person has to be valid status until October 1st, which is when the H1B validity starts. So it's really difficult for that to happen because the validity of a B2 is limited to 6 months and B1 is, can be anywhere from 1 to 3 months. So it's difficult to bring about that what you want. So often what happens is, a consular processing might be easier to do rather than a change of status in this situation, unless you have fulfilled those requirements and you have an I-94 for the B2 until October 1st, then absolutely you can go ahead and do it.
Okay, and there's an extension there from the same person. Also, if you're filing for H4 to H1B and the candidate has H4 extension pending, what happens if H4 extension is approved after H1B?
So you're filing for a H4, from a H4 to a H1. And at that point, when you're filing, I guess the H4 extension is, so whatever you file last, it's the last action rule. So whichever application you file last, that application prevails. So since you filed the H1B last in this example, your H1B will be your status, not your H4. Unless, of course, you withdraw your H1B before it gets approved, then your H4 obviously will be your primary status. So just remember, last action rule, application that is filed last.
Last action rule. Cool. All right. Next question is, currently I was working for a client in Texas, but I'm located in Chicago and it's a remote role. Should I file LCA and H1 based on client location or my location?
So you would most probably have to file an amendment, and you have to file an amendment whenever the work location in the LCA changes. So if the work location in your LCA is different from what it is right now, which it looks like it is, then you have to file a H1B amendment. Just changing work location within the same county or within the same MSA or metropolitan statistical area doesn't require you to file a H1B amendment, or changing for a short period of time doesn't require you to file a H1B amendment. But in your case, looks like your work location was previously Texas and now it's Chicago, so most probably you'll have to. You haven't said what the work location is in the LCA. You've said your client location is Texas, But what we want to know is what your work location is. And if that has changed as per the LCA, then you have to file an H1B amendment ASAP.
Okay.
In fact, you should have filed the amendment within 30 days of changing or even before changing your work location. And this is the problem actually with a lot of remote cases, remote filing cases. And I just wanted to bring that to everyone's attention that if you are an employee or you are an employer, when you're working remote, your employer doesn't necessarily know where you are. So always keep in mind, make sure you inform the employer if you are moving your location, and make sure you inform before you move your location, because an amendment will be needed. Recently, I had an FTNS site visit where the person and all these FTNS visits are visits that are made by these contractors that work for USCIS, and they usually make a visit to verify the information in the LCA and the H1 after the approval. And so there was this FTNS visit. The person was not at that location where they said they would be in the LCA. The employer had no clue that the employee had moved. They moved from Texas to California, and it was a big mess. And you can't predict which case will be an FTNS visit and they do not tell you that they're going to visit. So please be careful about changing your work location, especially when you're working remote, changing your home location.
Great insight, Pat. So there are a couple of questions from this individual. I have H1B stamped from 2016 till September 2019 and expired with no travel from India. What's the chances now for me to get the unused H1B visa?
No travel from India. Does that mean that the person was on H1, actually never traveled to the US, and never worked in the US on that H1B? In which case, you have not really used up any time on your H1B. So you have all these 6 years remaining on your H1 because you never used it up. It's not about the duration of the approval. It's about how much time you actually spent in the US on a H1. So you can get all the time back on the H1.
Okay. Okay. The follow-up to this is I have valid B1, B2 visa till August 2027. Any possibilities to travel US and get an opportunity in there and transfer to H1B?
Now the main issue is with this is whether you're CAP exempt or not. And I would argue that since you have previously filed a H1, and since that H1 is valid within the last 6 years, meaning it's not more than 6 years old, I would argue that you are H1B CAP exempt, which means that you should be able to file a H1 at any time, and you can file a change of status after coming into the country as well. But you have to remember that the interpretation of what is CAP exempt and what is not keeps changing, and sometimes officers will say that since you never actually worked on the H1, you're not CAP exempt and you're subject to it. So just keep that in mind, but I think it's doable.
Yeah, the individual has given us some context here. I had my MS degree from US in 2008 and post that had OPT employment till end of 2010 and then back to India for good reasons. Based on this, will I still fall under MS quota of 20,000 under H1B visa, else a general 65,000 visa category?
Since the person has a master's degree from the US, doesn't matter when they did it, they will fall under the master's quota if they were subject to the cap.
Okay, great. All right. I'll go to next question. If H1B gets picked in around October, while I'm applying for, I think it's I1, L1,
yeah.
L1 as well, would that create any issues for the candidate to any one of the visa?
So H1 is picked. So I'm not understanding how H1 will be picked in October. So H1 registration is already done and you should know whether you've been picked or not. So again, even though the question is not clear, we can still answer it. If you're filing two petitions, a H1-B and an L1 simultaneously, then whatever you file last, again, last action rule, whichever you file last, that prevails unless that particular petition is withdrawn before approval. So if you file the L1 later and the H1 before, then the L1 will be the one that will be your status once it gets approved.
Okay.
Of course, there is a further complication in this, and I don't want to confuse our audience, but if it's for a future date, then October 1st, for example, then that makes a difference as well. Then that overrides because it's not for a present date. So I think this person has to be more clear with reference to their question, so we can answer it specifically, and I don't have to go into this whole the entire gamut of the law.
Yes, and again, this is
yeah, but again, in general, last action rule, whichever, simple answer is last action rule, whichever case was filed later, that case prevails if it was not withdrawn.
Good to know. And just a reminder for everyone out here, this is a good scenario. These are very specific questions. So I would highly recommend booking a consultation. How can you do that? You can do that by leaving your email address on the chat. We will make sure that we follow up with you, or you can go to our website and submit a form, and we can book a consultation from there as well. Next question is, will H4EAD will get approval this year? If not, then what is the chance of that happening and when?
Again, I don't quite understand the question because H4 EADs, maybe they can retype the question, but H4 EADs are a thing already. So it's not something that has to get approval from anybody. I'm not sure if they're talking about the processing time. If so, then processing time will improve greatly if you file along with your spouse's H1. Otherwise, it is still taking quite some time. If not, what is the chance of that happening? Yeah, I don't understand the question, so you need to rewrite your question. Okay. Because H4 EAD is already available. If your spouse has an I-140 approved, H4 EAD is already available. So you should be able to file your H4 EAD provided your spouse has an I-140 approval.
Sounds good. Prashanthi, we still have a few more minutes. We got some questions offline as well. So I'll ask a couple of those real quick. Will the registration notice for selected cases for FY 2024 indicate if the selection is based on regular or advanced degree cap?
Yes, the registration notice will say that it's master's cap or it's bachelor's cap. It will.
Okay. What is the required US degree? What if the required US degree will not be awarded by the time of the filing?
So we know that as of the date of registration, you don't actually have to have a master's degree if you're filing under the master's cap, but you have to have a master's degree as of the date of filing your H1-B. And we know that we have to file the H1-B by June 30th, 2023. So if you don't have a master's degree by then, as long as you have completed all the requirements towards the degree, that's fine as well. You can submit the final transcript, or you can submit a letter from the registrar of the of your university confirming that the beneficiary has completed all the requirements towards a master's degree, but the degree maybe has not yet been awarded, due to maybe convocation didn't take place, etc., etc. But I would be careful in this scenario, Vishal, as to make sure that the letter is given by the registrar and not prepared by some unauthorized employee at the school, stating that the student has completed the requirements when in fact the student has not. If this is done, and this has been done in the past. So this would lead to not only denial of the case if that happens, but also it could raise a fraud issue as well. So I would just be careful who is giving the letter when you're accepting such a letter. So we have to make sure that the degree, the individual will have the degree by October 1st. Actually, I'm sorry, that you have to have the degree as of the date of filing, period. You can't argue that the degree will be there by October 1st because the start date of the H1-B petition is October 1st. You can't give that argument because USCIS has said over and over again that you have to meet the requirements as of the date of filing, not as of the start date of employment. So that's quite clear.
Okay, thank you.
Also, a quick thing about master's degree cap cases. Not only should it be a master's degree, but it has to be a master's degree from an accredited organization, and you have to follow the rules of USCIS with reference to who is accredited and who is not. And also it should be from a not-for-profit, that is a non-profit, or a public organization. Cannot be a private institution. So these are the additional requirements for master's cap.
Very, very detailed, very thorough there. We still have, we've just got a few more minutes to wrap this up, and there are a few new questions coming in. I'll answer that. Just a quick note before we wrap up, we will be, as a token of appreciation for joining us today, we will be offering a complimentary consultation session to some early bird attendees. So if you are interested in booking a consultation with us, I would recommend drop us your email on the chat, and we will follow up with you post the webinar. The next question I have here is, I have a consultant working for a X company and he has 6 months left on H1B. He requested if my company can transfer his visa and apply for PERM. Do you think we can do that?
I don't see why not. If they remember, you have to show that it's not speculative, that you have to show that you have a job for the person. So you can file I see the issue here. You only have 6 months before his H1 expires, the 6 years, and the PERM, if you file, you cannot file the PERM immediately. Nowadays, just the prevailing wage takes a year and the PERM will take another year. So that's a total of 2 years, and the prevailing wage period is not counted. But from the date of filing the PERM, it's counted for AC21, which means that if the PERM has been pending for more than 1 year, then you get an extension of 1 year. If your I-140 is approved, you get an extension of 3 years. I don't see either of those scenarios playing out here if you have only 6 months left, unless there is time that you can recapture. If the person has spent a lot of time outside the country in the last 6 years of their H1, you can try to recapture that time and see if that gives you, that will still not give you a year. It might. So you have to see that, you have to do that analysis, or you have to see whether the person can move to a different status, such as an F1 or a H4 for that period of time that it takes for the labor to at least be pending for a year, or for the I-140 to be approved. So you have to see what your options are by doing an analysis of what the facts are in this person's case. So it is possible, but it's hard.
Okay. We only have about a minute left, so we'll be taking up your questions. But if you're not able to get through all of the questions, please drop us an email and we'd be happy to book a consultation. Next question is, as per USCIS's official website, the 65,000 quota is there, but 127,600 have already been selected by them in the first round lottery. Then how it works?
So maybe the question here is, Subhashish is asking why more cases have been selected if only 65,000 are available. Actually, we know that there's 65 plus 20. They're selecting more because they know that a lot of people will not file because they know that there have been duplicate registrations. In fact, there are people who filed 15 registrations. One applicant that's filed registered 15 times through different companies. 20 registrations. So it's amazing the number of registrations that have been filed by single individuals. So obviously they will not file the H1 15 times and only file it one time. So they know that a lot of registrations will go waste and will not be filed. So they are trying to take more people than are needed so that they can account for that. If they're unable to, or if they're still account for it because they didn't do, a correct analysis, and it's hard to kind of predict how many will be used and how many will not be, they will most probably have another lottery for the existing registrations. Last year they had only one lottery. They claim to have made a prediction correctly of the number of cases that were being filed. The year before they had three lotteries, 2 or 3 lotteries. So I know they had a lottery in November as well. It's hard to say what will happen this year, whether they'll have another lottery or not. We have to wait and see.
Great. We'll take the last question very quickly. If H1 is picked in lottery this year, but employer isn't showing interest to get employee to US from India, can we proceed further for that consultant where H1 is filed by another employer?
Well, at least the H1 has to be filed. If the H1 is filed and approved, then you can argue that the case is H1-B cap exempt and you can file a H1 anytime through consular processing. But if only the registration was picked and the H1 was not filed, then you cannot use another employer's registration to file through your company.
Okay, great. Well, Prashanthi, thank you so very much for this highly insightful session. We will have to pick up any more questions over email or offline. So if you are interested in getting a complimentary consultation session with us, now is the time. You can drop us your email and we will be happy to reach out to you post webinar. I will leave the chat open for another couple of minutes so that you can drop in your email address. Prashanthi, thank you so very much for your time.
Thank you so much, Vishal, and thank you everyone for listening patiently and for registering and showing up at the webinar.
Thank you, Prashanthi.